recognize the Africa Director of MacArthur Foundation, Dr. Kole Shetima, who is more or less like a father to most of us here, and then our colleague, Barbara Megare, who I call Her Excellency the Manager. So this is a welcome remarks on behalf of the Cleen Foundation. Distinguished guests, ladies and gentlemen, it is with sincere pleasure and on behalf of the board, management and staff of Cleen Foundation that I warmly welcome you all to the dissemination of research findings on the Administration of Criminal Justice Act 2015. By way of introduction, the Cleen Foundation, as we all have been told by my colleague, was established in 1998 with the mission to promote public safety, security, and accessible justice through the strategies of empirical research, legislative advocacy, demonstration programs, and publications. And we do these in partnership with government, civil society, and the private sector. In our 22 years of existence, we have driven about advocacy mainly through research, and this dissemination is actually one of our key deliverables as an organization. The Administration of Criminal Justice Act 2015, as we know, has brought fundamental reforms to our criminal justice system. The Act was designed to not only preserve and strengthen existing legal frameworks, but also enhance the efficiency of institutions within the criminal justice system and the protection of human rights of citizens, including complainants, suspects, defendants, and victims. Of course, we know that our criminal justice system is very interesting. We have initially we used to have the Criminal Procedure Code in the north and the Criminal Procedure Act in the southern part of the country. But now the Administration of Criminal Justice is actually meant to bring these two different legislations into one component act. The legislative purpose of the Administration of Criminal Justice Act 2015 is to have a nationwide application, thus to introduce a national criminal procedure law that will regulate the investigation and prosecution of offenses throughout the Federation. The Act, being an act of the National Assembly, is only applicable to the Federal Capital Territory and to federal courts and other federal institutions, including the Nigerian Police Force, Nigerian Correctional Service, and other law enforcement agencies, even as the states continue to adopt the Act. For those of us who have a little understanding or who have an understanding of the Constitution, you realize that criminal law is not in the exclusive legislative list. So that means that states have the power to legislate. And that is why the law that was passed by the National Assembly is only applicable in Abuja, and states are free to domesticate it in their various jurisdictions. But there has always been this argument whether the Administration of Criminal Justice Act applies to different commands, the police command in different states of the Federation. The answer is yes, because the police, the prisons, and other criminal justice agencies are creations of the federal government. So the law automatically applies to them. So even if a state has not adopted the criminal justice, Administration of Criminal Justice law, and you are taken to a police station, the Administration of Criminal Justice Act 2015 automatically applies, because the police, in all the commands, they are creations of the Federal Republic of Nigeria. So far, 29 states out of the 36 states have already adopted the Act. However, despite the passage of this Administration of Criminal Justice Act, its effective implantation into the national criminal justice system has remained slow, and the age-long challenges in the criminal justice process for which the Act was enacted still persist. Of course, we know that one of the provisions of the Act is that when a criminal is to make a confessional statement, that criminal has to be, the confessional statement has to be put in, it has to be recorded with a video, and then the lawyer of the defendant has to be around. But of course, we know that sometimes when you go to police stations, they will say that they don't even have a pen or paper for somebody to write a confessional statement, not to talk of the luxury of having video recording and all those things. But we hope that one day we'll get there. So while concerted efforts are being made from various quarters, state and non-state actors alike, the need to sustain momentum on the advocacy necessitated Cleen Foundation and other partners to design a follow-up project targeted at strengthening accountability and transparency in the criminal justice system in Nigeria through sustained advocacy and monitoring of implementation of the Administration of Criminal Justice Act 2015. Through its continuation, our present project deepens the data collection process on the Administration of Criminal Justice in Nigeria, which was initiated under a previous project on monitoring the implementation of the Act, and also to continue monitoring the implementation of the Act in different parts of the country. It should be noted that previous surveys on monitoring the implementation of the Administration of Criminal Justice Act were carried out in 2018 in the 12 states comprising of 2 states per geopolitical zone in Nigeria, and this was done by Cleen Foundation in 2018. The result of that survey indicated low-level awareness of the Act, both by the general public and criminal justice actors, which necessitated a scale-up in this phase of the project to cover the 36 states of the Federation. So what I'm just trying to say is that in 2018, when we started this project, we had done a pilot project selecting 2 states per geopolitical zone to carry out this survey in order to know how people understand the criminal justice system and what changes have been made with the Administration of Criminal Justice Act. What we found out is that a lot of people, even those who are supposed to know, both lawyers, police officers, did not really know much about the law. And that's actually what necessitated that we should do this again. And the difference between what we did in 2018 and what we are doing in this year is that initially we just had 12 states. But in the survey we are going to release, we did 36 states. So we covered the whole country. And the sample size also increased. And I hope you see some differences. The report of the 2018 survey is actually on our website. That's www.cleen.org. And we encourage you to visit our website as often as possible, because the report of this survey will also be posted there once we finalize. So the primary objectives of this project includes providing reliable and credible data on the implementation of Administration of Criminal Justice Act 2015 and other similar state-related laws that can support stakeholders and citizens to understand better the extent, trends, and challenges in the implementation of the law, as well as its domestication by states in order to drive robust advocacy. The second is to improve the knowledge and technical capacity and skills through training of law enforcement and security agencies personnel to effectively understand and play their role in the implementation of the Act. Since last year, we've been carrying training programs in all the area commands, and we will continue that. I think what is remaining now is some of the geopolitical zones. Actually, we are doing training in all the police commands, so we bring the zones together. I think it's only 2 zones that are remaining for us to cover the 6 zones in the country. The third issue is supporting the official documentation by responsible agencies of progress made in the implementation of the Administration of Criminal Justice Act using the indicator system which aims to systematically monitor compliance with implementation of the law by relevant agencies. What we've also noticed actually is that the Nigerian police personnel requires a lot of training and retraining in terms of gathering of evidence and also using that evidence in actually a court of law. And that is actually one of the key things we have done in our interaction with police personnel. So we brought key police officers from the 6 geopolitical zones to Abuja and did a TOT, training of trainers. And these are the people we are now using for the step down that is happening in the regions. And it has been an interesting opportunity for police officers to also get other police officers to know about the Act and how to use it in their daily activities. The fourth objective of this project is enhancing public awareness on the provisions and implementation of the Act through development of documentaries spotlighting critical criminal justice issues and the development of IEC materials for the police and citizens. Distinguished guests, the meeting today is to share with you summary findings from the first round of the survey conducted across the 36 states and the FCT on the state of criminal justice administration in Nigeria. On this note, we would like to express our appreciation to MacArthur Foundation for supporting us over the years and actually supporting this project. Like my colleague Wale rightly pointed out, we are members of the criminal justice cohort, and we were privileged recently when the president of MacArthur Foundation visited Nigeria to actually meet with him and discuss the challenges, the opportunities, and the successes we have recorded over the years.
I'm very happy and very glad to be here this morning. I think this is really one of the most important things that we do. We have been working on the ACJ for some time now, and I think that trying to find out the results of the survey is something that all of us are keen about and see what is happening. And as I was thinking about it, I was also thinking about how long that we have supported Cleen in the 22 years of its existence, probably for the last at least almost 20 years or so. The foundation has been supporting the Cleen Foundation. Benson, don't clap. But I was just about to say that I think you should be an adult by now and be able to stand on your own after being pet for 20 years or so. But certainly Cleen is one of the organizations that we value the work they do, the contributions that they are making in Nigeria, especially their attention to research, to evidence, but I think this is critical and very important. For those of us who do work in policy advocacy, I think we need to have the evidence in order to make the argument in terms of what we do. And that is one of the areas that Cleen Foundation does very well. The second reason why we think Cleen work is very important is that they also do a lot of work on the supply side. I think that is also critical and important. So whereas it's good to have people who are advocates who will draw government attention to some of the shortcomings in our things, I think it's also sometimes it's important that you support groups and organizations that will work with government agencies so that government agencies can improve the quality of the work that they do. So we see Cleen's work as that aspect of work contributing to that knowledge and strengthening of state institutions. And I think those two are big reasons why we think that the work of Cleen is important. It's important for me to hear. Despite the fact that I'm supposed to be at the Hilton for another meeting, and my people in Hilton have been harassing me, why am I not at their meeting? Why am I coming to the foundation meeting? So because of that, I'll take my leave from about 11:30 so that I'll be able to join the other meeting. But let me once again join everyone to welcome you all to this very important occasion.
That will be very key aspect of the findings. Over 200 tables have been generated. And then there are two levels of analysis. There's national analysis and then state-by-state analysis. The state-by-state analysis is not something you can actually see the figures if they are projected. So we're going to be focusing on the national level analysis today, the key issues. Actually, like I said, and the person talked about methodology, talked about the length of the questionnaire. So it's not something we can cover the whole content. At the end, maybe what we expect at the end is that on many of the issues we have to compare what we had in the previous survey compared to the present situation so that we are able to tease out trend in many of the issues we are interested in. I think I should just highlight this is my own thinking of what Acja, or Administrative for Criminal Justice Act, tried to achieve. I think first and foremost is to speed up achieve speedy and impartial criminal justice process and adjudication in Nigeria. We talk about prison congestion, we talk about awaiting trial, we talk about frustration of citizens. This basically has to do with two key things. One is the very long process of criminal adjudication in Nigeria. Even in very serious cases, you find people are under trial for years. There are people detained in the prison for 10 years. Their cases have not even been concluded, not to talk about being convicted. So, administration of criminal justice, the primary purpose was to ensure speedy trial and also to ensure impartial criminal adjudication. The second one is, of course, protection of human rights within the criminal justice system and process. Of course, the entire criminal justice process is supposed to be a mechanism for promoting human rights. When you violate people's rights, the criminal justice system is supposed to provide a redress through process of prosecution, sentencing, and conviction and sentencing. Then the third one is, if you look at the criminal the Acja, it expanded the range of penalties and corrections available for convicts. So we find all kinds of new penalties that have been introduced that were not previously in any of our legislation. So these are the basic, for me, the way it can be summarized, the basic objective. It is in this context that we want to see whatever progress has been made. So in terms of background of people involved, we just heard about the methodology. 51% of them were male, and then 49% were female. About 61% were under 35 years or younger. Most people had higher level of education. About 89% had secondary and higher education. Of course, it consisted of 78% of people from the general public, and then 22% of people from different vocations within the criminal justice system. Then finally, you find that 67% of them are from urban, and then 33% from the rural area. This is important when considering the findings, because where you collect your data, how you collect it, can affect the result that you get. So that's the background of people who responded to the question. Now, the next issue, the beginning is, what is the extent of citizens' familiarity with criminal justice agencies? How much do we know, even the criminal justice agencies? What level of familiarity we have? It's not surprising if you look at the figure. Police, most of us have understanding or familiarity with the police. 81% of the respondents said they were familiar or very familiar with the police. The response there is those who said familiar and those who said very familiar, they are combined. So 81%. So among the criminal justice agencies, the police have the greatest contact with citizens. I think that point should be made. They have the greatest contact with the citizens. And that's why we often said that the police is the gateway to the criminal justice system. What police do or do not do influence the entire thing that happens within the criminal justice process. For example, if you commit a crime and you are not arrested by the police, that's the end of the matter. If they arrested you and did not charge you, that's the end of the matter. But if you do not commit a crime and you are arrested by the police, you still find yourself within the criminal process to go and prove your innocence. So the police are very critical. You cannot make any impact on the administration of criminal justice system if you do not address the issues associated with the police. And what are some of the issues? They are not even with the police itself as much as the quality and types of laws that you ask the police to enforce. The type and quality of law you ask the police to enforce. You know, we used to have a law on wandering. That means police can just come 8 p.m. and they see a group of you, just hanging around a corner, and they arrest you, and they say you are wandering. And of course, it goes, if you don't have means of livelihood, so if you don't have an identity that shows that you work in an important place, that creates even further problem for you because you cannot show means of livelihood. So, until 1986 or thereabout, when we must thank him for that, irrespective of what we blame him for. I think it was during Babangida that particular aspect was expunged from our law. So, the kind of laws that the police are asked to is outside their responsibility, outside their power. But once a law is enacted, it's the responsibility of the police to enforce it. Why am I emphasizing this? It means that we need also to understand what is the character of our law. What's the character of our law? Because if you keep blaming the police and the law is on the law book, then you are not going to make progress. It may be discretionarily applied, may be applied to one person under the other, but it's still on your law book and it will be applied. So we need a lot of, first to understand, are the laws in our law books all relevant? Should all of them be criminalized? Or we should find alternative means of dealing with many of the issues. I think police is overburdened with a lot of issues that can be decriminalized. I think that's my own conviction. There are many cases that are very common that tend to dominate their position. If you go to a typical police station in not very rich area, you will find the kind of cases that people bring. These are cases that should be determined by some kind of non-criminal process. Or, alternatively, we may consider thinking about giving the police power of reprimand. That means there are cases that can be determined and responsibility. The police can dispose with the case, but there will be an entry of that case, a record of the, that case occurred. Some kinds of, ban the people to be of good behavior. Because I just want to say that's one of the things that affect the police. So of course, we have the capability of the police, what kind of facilities are available to them to carry out their work. So police is the closest to the citizen, followed by the courts, followed by the prison, followed by EFCC, and right down the line, National Human Rights Commission is the one that people have probably the least familiarity with. Again, that is understandable. Only you big people in black coats, like my executive director, and the legal man from the police, and the rest of you from heavy civil society organization, you are the one who talks about national human rights. It's not yet a common thing where people seek redress. So that is the extent of familiarity with these agencies. It's important also, when you talk about familiarity, how it affects the other information. The next issue that we tried to bring about was to respond to a question about the extent of demand for the services of criminal justice agencies and level of satisfaction with outcomes. From which agency do we demand the greatest service? Again, if you look at it, it's the police. Police, about 38.1% of the respondents said in the last 1 year they have actually demanded for the services of the police. Then followed by, I think, lawyers. These lawyers consist of both defense attorney and the ones in the ministries and the rest of them, followed by lawyers. Of course, if you are arrested by the police and you have some money in your pocket, you have to contact a lawyer. Then, of course, you are going to appear before the court. So you find the trend actually makes sense. Police being the highest, followed by lawyers, then the court. Because some of the cases don't eventually get to court when you talk to lawyers. So that gradient actually makes sense in the order that they come. Of course, judges next. If you go to court, you must of course encounter judges in those courts. The others, like the prison, is usually at the tail end of the process of remand. Then, Director of Public Prosecution. It also makes sense because except you are involved in very serious cases, you do not need anything from the Director of Public Prosecution. The police are empowered to do that. I think it's in capital, in life sentence and capital cases involving capital life that are almost mandatory. You must get a legal opinion of the DPP. So, in terms of demand for service, again, police is at the forefront, which again reinforces my position that if you want to reform the criminal justice, you must start from the, from the gatekeeping.
Okay. Our vision and mission as African Polling Institute is to become a leading opinion research think tank in Africa, championing good governance by producing and disseminating credible data on public opinion to support decision makers, policy makers, and advocates. Our mission is to disseminate credible African-owned opinion surveys, or opinion polls, surveys, social research, and evaluation studies to inform better decision, public policies, practice, and advocacy. Okay, just to go straight into the methodology that was used. So the executive summary of the whole survey is, API was commissioned to conduct data collections and analysis for Cleen Foundation to gain better understandings of citizen assessment of the implementation and the administration of criminal justice law and the overall administration of criminal justice system in Nigeria. The fieldwork commenced on the 14th of October 2019 and ended 1st of November 2019. That's about 3 weeks of fun. But in total, we were able to reach out to 11,813 respondents were reached out to, and of which, we have some level of outright refusal, some decline, and all that. So while 11,553 questionnaires were completed, and a total of 175 enumerators and 40 supervisors participated in the survey exercise. Okay, the methodology we used now for this, so the survey is for both general public and the special public. The special public is a component of where we have the police officers, the lawyers, the judiciary officers, and the correctional service officers. So, for the face-to-face, which is the general public, API adopts a face-to-face household multi-stage stratified random sampling technique for the general public, and purposive sampling for the special public using the sample list and contacts gotten from Cleen Foundation and API database. We used the multi-stage random sampling techniques for the general public, where the samples, where we use the 2006 population census to draw the samples, to cut across the state, and of which it was further broken down into senatorial districts. And from the senatorial district, we take it down to the local government levels, and from local government level, some communities were visited. So for the special public, considering the fact of the technicality of the question, there are people that we cannot just get, within the general populace. So we have to apply the more purposive sampling, where we have a list gotten from Cleen Foundation and the database for API, which we have over time to get the special public. So enumerators also apply snowballing, because the list we have was not exhaustive enough to capture the entire special public sample for special public that was set out to achieve. So in that case, we applied a snowballing techniques to access other special public, special respondents, which is the police, the lawyers, the prison officers, and the judicial officers. Due to, like I said, due to the technicality of the survey and the specific target respondent required for the study. Okay, so the sampling procedure that was used for the general public, like I said, which is the multi-stage stratified random sampling technique. We broke the sampling down into state, like I said, then from the state level, it was broken down into the 3 senatorial districts of each state. Then from each of the states, we now survey local government, to have a total coverage of the geographical landscape of the selected state. Let's continue. So for the general public, it was an household survey. So selection of household now, in each of the community visited within the LGAs, because in each of the central districts, we visited some local governments to cut across the senatorial district. So within the LGA, some communities were visited, starting points were identified. The first household close to the starting point were selected for the first interview. So after which a random route work was applied. That is, in urban sentiment, in urban, for example, if you interview the first household, so you have a 1 in 5 ski pattern. So to have, so your samples will not be clustered within the same region, within the same area. So we applied 1 in 5 sampling gap in the urban, while 1 in 3 in rural, because of the population and the settlement. So for respondents in each of the household, in selecting adult respondents due to the nature and technicality of the survey, adults 18 years and above, were selected in each of the household. So we use pitch grid. So pitch grid is a scientific method of selecting respondents. So you won't just walk into an household and just pick anybody. So we have a pitch grid that was used, listing all the household members. Then the pitch grid will tell you which respondents to be interviewed. So after selecting the respondent and you were asked, the respondent was not around. So we visited, we have to visit 2 attempts. So we visit 2 attempts for the respondents. After that, if they are not available, then we can substitute the household and the respondents completely. Thank you. Let's go. Okay, so after the whole, during the survey, so these are the experience we encounter on the field. General field experience and limitation. So the survey witnessed field limitation across the state with regards to administration of criminal justice, administration of criminal justice law and acts. So one limitation faced was the huge apathy from prospective respondents. So most of the respondents were not actually willing to participate, so they feel somehow lazy. So we witnessed several instances where eligible respondents, both within the general public now and the special public, were skeptical to participate in the survey for fear that their responses may be used against them. So at this instance, our enumerator had to explain the purpose of the survey and reassure them that will not be traced back to them. So assure them of the confidentiality of participating in the survey. So similarly, there was general apathy among the special public, especially among the police, prisons, and judicial officers, while most of them expressed skepticism and stating that they are civil servants with no authorization to answer interview. So in the same manner, most special public respondents expressed concerns that their introductory letter were not directly addressed to them. So at this stage, it took us, several persuasions and multiple assurances to get them to participate. Even at that, some of them still refused. So what we did at API was to now draft a letter directly addressed to them. So we asked the enumerators to go, make sure they confirmed the name of either the DPOs of that stations or the Comptroller General of the Correctional Service. So we addressed the letter to them directly before we were given access to the interview. In addition, most respondents were skeptical about disclosing their identity, such as names and phone number, because of the nature of the questions that we have. So some of them refused to give us their names and phone number because, they were trying to avoid them being traced back to, their responses. So also, given the state of insecurities in few northern states, some men did not refuse and not allow us interview their wives grant any interview, even with use of female enumerators. So we had to keep persuading them to make sure that the entire process was going. So still on the fieldwork experience. So gaining access into some communities in the south, southeast, and part of the north, initially proved difficult. So we encountered instances where youth were asked for financial incentive to grant our enumerators permission to conduct the survey in their community. So they were saying we cannot just budge into their communities, and start talking to people. So we have to wet the ground and all that. So that was settled, and we proceed. But actually, did that actually delay us for some time? So another challenge which is important to highlight, like according to the respondents, which happen to be most of the special public, because they actually said the length of the question the length of the questionnaires are much, considering their time given to us. So on average, it took over an hour to conduct an interview with the respondents, and it was challenging to keep the attention of respondents. Most respondents complained about the length of the questionnaire while expressing their concerns that their time, that there was no form of incentive, for taking their time. So it's extremely important to also highlight the difficulties we encounter on the field, having access to police, judicial officers, and prison officers willing to participate in the survey, even with contacts provided by Cleen. Some of them still feel, they don't want to be part of the whole process. So, they kept referring us back to the state commissioner of police or their divisional headquarters or the Comptroller General. So we had instances where we were asked to also draw hard copy questionnaires for special public now, because they feel sitting together with interviewers, filling the questionnaires, it takes a whole lot of time, because they kept whatever they are doing, they abandon whatever they are doing to make sure that they are part of the process. But the unfortunate part is, after dropping the questionnaires, we get back to them for retrieving the questionnaire. Most of them said, they started completing the questionnaire, but unfortunately, because of the length of the questionnaires, they could no longer proceed. So at that point, that gives us a whole lot of, incompleted questionnaires. And but if you look at the executive summary, so we have 11,813, out of which we have 11,553 completed. So over 300 refusals, incomplete, and all sorts. So it is worth noting that our enumerators and supervisors encounter security issues in Kano, Zamfara, and Ogun State, where our enumerators were considered intruders and were apprehended by security personnel, despite showing reference letters and ID cards. So they refused to release them, claiming anybody can draft a letter with whom it may concern. So it took intervention, calling several people for them to be released. So that actually takes a whole lot of time. So lastly, it will be useful to state categorically that the assignment was conducted with extremely tight budget with very little opportunity to enable appropriate community entry, like I actually mentioned earlier. So we couldn't afford to pay to wet the ground, to pay cola for the community leaders and the youth groups, so to say. All right, so let's continue. Okay, so in conclusion and recommendation, so based on the observation and experience from field, API recommend that for future survey of this nature, introductory letter be addressed directly to the state headquarters of each stakeholders in order to enable field workers gain better reception. Also, there is need to reconsider the length of the survey instrument in order to reduce respondent fatigue and the rate of incomplete interviews. Furthermore, there may be need to introduce some incentive to actually appreciate respondents, especially the special public, who are taking time out, of their busy schedule to participate in this kind of survey. So the general public, overall now, so the general public seems not to be very much aware of the administration of criminal justice. So, we advise that there should be need for more awareness to educate the populace on the heart.
Collaboration, particularly on our criminal justice work. And for me, it will be interesting for us to see what the surveys are doing. So as part of the cohort, P1 also observes implementation of the ACJA in the states, in the FCT, and also at the different states where we observe implementation of the law. It will be interesting for us to see how some of the information either correlates, or there are challenges, or there are issues that we can bring together to see how we can resolve some of the issues in the criminal justice system. I remember some time back, Dr. Shetima tried to draw attention to the need to try and see how some of us that are doing this work can develop a synchronized survey instrument. At the beginning, I know we had some kind of reservations. Can we do that? Do we need to do that independently? But I remember about 3 weeks ago, some of us working in the cohorts, and I think a representative of Cleen was also there. Some of the things we're seeing on ground is the need for us to develop survey instruments that are collective, that necessarily have information that all organizations can pick from. Feelers from some of the practitioners is there is a fatigue for data collection. They are tired of answering the same questions. I know this methodology might have been different, but just giving that as a feedback. And so I'm sure going forward we'll begin to rethink how we will ensure that this is done collectively. So once more, thank you for inviting us, and thank you even to MacArthur Foundation for supporting our own work to administration of criminal justice.